Yeah, we have with us the former Chief Justice of India, Honorable Justice D.Y. Chandrachud. He would share his thoughts on the Indian Constitution, which has turned 75 years old, the ever-evolving, vibrant Indian democracy, and the Indian Republic, which has seen so many struggles, and also the role played by the judiciary in this evolution. Hearty welcome, Justice Chandrachud.
Thank you very much for having me as part of this program.
It has been referred and it has been pointed out quite often that the Constitution has been the site of struggles, a constant conversation with power. How have your experience been vis-a-vis the Indian Constitution?
When it was framed and adopted, the Constitution represented two distinct strands. First was the transfer of political power from a colonial regime to a homegrown regime. So the first aspect of the Constitution was the transfer of power and the creation of India as a democratic society governed by the representatives chosen by the people. But equally, there is a very important second strand which emerges in the Constitution, and that's the process of social transformation. So the Constitution was always intended to be not just as an instrument witnessing the transfer of authority from a colonial to a homegrown regime, but as an instrument of a broader evolution of society. And that second strand has been witnessed to social movements, whether it was in terms of the establishment of the dignity of segments of our population who were discriminated against for centuries, like the Dalits, the quest for dignity for the scheduled castes and scheduled tribes, in other words.
Yes.
Equally for other social movements which took place within the framework of the Constitution. So you find at different stages in the growth and evolution of India as a democratic nation that there have been different challenges which have been faced. So in that sense, you see that the Constitution, in the process of its evolution over 75 years, has witnessed different stages,
Yes.
showing a conflict or a constant churning between the rights which citizens have adopted. But it has been the site of a dialogue between citizens and the government, and between different levels of government, the state governments and the center, for instance.
Lots of in the Constitution, courts has got a critical role, and Constitution is right now in a critical, in a very crucial phase. Do you think that courts are delivering the duties?
Well, I believe the Constitution has been in a critical phase since the birth of the nation itself, be it in the context of personal liberty, be it in terms of the quest for equality, or be it in the context of modern issues which have now arisen, such as climate change or the growth of the internet and social media. So the nature of the challenges which come up before the courts have changed over a period of time, but the fundamental principles which the courts have to apply are principles rooted in the Constitution. And I believe that our courts, particularly the Supreme Court, have been at the forefront of the quest for protecting personal liberty. So at every stage you find that courts have applied and evolved new concepts. In the context of climate jurisprudence, courts have developed the polluter pays principle.
Even at the time of majoritarian rule, you feel that courts are delivering its duty?
Well, it's always majoritarian rule, because any government, to survive parliament, has to have the confidence of a majority on the floor of the House. So in that sense, the existence of majoritarian rule does not dilute or alter the status of the court or the responsibilities which are cast on the court. And therefore, you do not approach a law from the lens of the law being necessarily unconstitutional. There is, as we say, the presumption of constitutionality of the law. But once a party who comes to court displaces the burden of why the law is not constitutional, then obviously the burden shifts on the government to justify the validity of the law.
Justice Chandrachud, you spoke of societal transformation, and the architects of Indian Constitution imagined that the Republic would travel forward, thereby broadening the horizons of democracy. And the chief architect of Indian Constitution, Dr. Ambedkar, emphasized the point that there should be due representation across the corridors of power. But the sad fact is that all the major institutions, including the Supreme Court of India, doesn't have the diversity reflected in these institutions. What is your take?
Well, I'll speak about the judiciary. I'll speak about the Supreme Court. Insofar as the Supreme Court is concerned, a very concerted effort is made to ensure that the court reflects a sense of diversity. And to my mind, the Supreme Court does reflect a sense of diversity. Until the retirement of one of our colleagues, Justice C.T. Ravikumar, just a few days ago, the Supreme Court has had 3 judges drawn from the scheduled castes. They're not appointed because they belong to the scheduled caste. They were appointed because they were good judges. They had a solid background in terms of the work which they did in the high courts. But at the same time, because they belonged to that community, they brought a sense of diversity to the bench. There's an active effort in the Supreme Court to ensure due representation to different religions without having specific quotas. Therefore, we have a judge from the Muslim community in the Supreme Court. We have a judge from the Christian community in the Supreme Court, a judge from the Parsi Zoroastrian community in the Supreme Court. In terms of diversity, there's a great deal of focus on diversity in terms of region. And a conscious effort is made by the Supreme Court, by the collegium presided over by the Chief Justice, to ensure while making recommendations that different high courts and therefore different states find adequate representation in the Supreme Court. Maybe that the larger states have more than one judge in terms of representation in the Supreme Court. Another aspect which is borne in mind is adequate representation in terms of gender. So we do place a great deal of importance on having gender diversity in the Supreme Court. At the same time, though I've made this point in response to your question, it's important that we understand that where does the pool come from for appointment, say, to the Supreme Court? That pool for the Supreme Court appointments comes from the High Court or from members of the bar, but we have predominantly appointments made from the High Courts. So in order for the Supreme Court to reflect a true sense of diversity, the High Courts must reflect that sense of diversity. And what is the pool for the High Courts drawn from? Pool for the appointments of the High Courts is drawn from the members of the bar and members of the district judiciary. So really speaking, if you want to bring diversity to the higher judiciary in the future, we have to begin at the base of the pyramid, which is the district judiciary. And a very encouraging feature is that over 50% of new recruits to the Indian judiciary at the lowest levels of the district judiciary are drawn from women, which is ensuring a degree of gender balance to the judiciary in the future.
The point is taken, but there have been some observations that there should be more affirmative action on the side of the apex judiciary, because it is pointed out that when a vacancy arose in the Supreme Court of United States of America some time back, the other judges and the stakeholders, they took a decision that there should be a representative from the black female community, and Ms. Jackson was appointed. I think, don't you think that there should be some such efforts on the part of the Apex Court of India?
Now, you spoke about the US Supreme Court. Irrespective of what the judges of the Supreme Court in the US felt, the power of nominating people for appointment to the US Supreme Court is entirely vested in the US President. And appointments to the US Supreme Court are political appointments. In contrast, appointments to the Supreme Court of India are not political appointments. These are appointments of career judges drawn from the High Court or from the bar, as the case may be. If you look at the website of the Supreme Court, which has the resolutions of the collegium, you will find that there's an elaborate discussion of the cases of specific candidates who are appointed on the ground that would bring greater representation, particularly to the marginalized groups in our society. So that's something which is taken into account. And as I said, there are express quotas insofar as appointments to the district judiciary is concerned.
Lordship, one of your very important judgment was Sabarimala judgment, and it was not fully implemented, and still it is in a suspended animation form. So, what do you think? It was often quoted that it was a very progressive judgment, but still governments are not implementing.
One thing which I have learned during the course of my 25 years as a judge is that you do your best in a case. When you hear arguments, you conclude arguments, reflect, and then decide. Once you have decided a case, particularly in a constitutional court, your work is at an end. And then it is the duty of the government or whoever has to implement the judgment. If it's a civil judgment, the parties who have lost the case, to implement the judgment. Speaking for myself, and I don't want to sound overtly philosophical, but I think my work is done when I have delivered a judgment and I'm not attached to the consequences which have emanated from that judgment. Sometimes those consequences may emerge in the immediate future. Sometimes the judgments speak to the future. The consequences of the judgment may emerge in the not immediate future, but maybe a distant future or not so distant future.
You have delivered some very remarkable judgments, including the one in Puttaswamy case, where you held that right to privacy is a fundamental right. And there you formally overruled your father's judgment in the ADM Jabalpur case,
Right.
which had held that right to life and liberty could be suspended during the emergency. What you really felt when you penned that judgment?
When I penned the judgment in Puttaswamy, the judgment in ADM Jabalpur was just another judgment. For that matter, I've overruled my father's judgments in Joseph Shine. The judgment which he delivered was in a case called Saumitri Vishnu, where he had upheld the provisions of the Indian Penal Code, which dealt with punishment for the offense of adultery. So both these cases, when you deal with a judgment as a judge of the Supreme Court, you are dealing with the judgment irrespective of the personalities which are involved.
Any inner conflict?
Oh, not at all. Because when you look at the case and the correctness of the validity of a case in the future, you are deciding upon the correctness of a view which was taken, say, 25, 30 years back, or even 10 years back, in the context of today's society. Many of those judgments were delivered in the context of our society as it existed at that point of time.
Romila Thapa case, your dissenting note, where you remarked, where you made this observation that dissent is the safety valve of democracy. That really raised the hopes of Indian people. And the Republic really felt that you are speaking truth to power and you are holding power to account. So how has been that moment, when you look back, how do you look at it?
That reflects actually my basic approach to decision making. In the case that you mentioned, I said that dissent is the safety valve of democracy. And that has been a guiding principle for my decisions over a period of time. And I delivered dissents, for instance, in the Aadhaar case. I was the sole dissenter in the Aadhaar case, where 4 of my colleagues felt that the project was constitutional.
Yes.
For me, the biometric project did not contain sufficient safeguards for protection of privacy. You know, dissents in that sense, and I have plenty of dissents in the Supreme Court, dissents speak to the future. And across the world, dissents have become the law in future times. For instance, my dissent in Aadhaar is not part of our law in that sense. It didn't become law in India. But my dissent in Aadhaar was used in another jurisdiction internationally as the more preferable view in striking a biometric scheme in a different part of the world.
And the trend these days has been to criminalize dissent. Those who really register a voice of protest, those who dissent with the establishment, they are arrested, they are put behind bars, and they don't get even bail. We know many cases where people have been denied bail and they're languishing in the prisons. So, what is your take on this?
My take is basically this, that our law contains a presumption of innocence. Whether bail should be granted or whether bail should be refused depends on the facts of a particular case. And the principles are well settled. The judge looks first and foremost at the seriousness of the alleged offense. 2, the judge looks at whether there is a chance that a person who is released on bail may commit the same offense or a similar offense. 3, the judge will look at whether the person who is accused of the offense, if released on the bail, would possibly commit another crime based on the antecedents of that individual. 4th, and very important from the perspective of protecting personal liberty, how long is the trial going to take place? If the trial is not going to conclude in the immediate future or the near future, it's an added reason for the grant of bail apart from the presumption of innocence. Now, you mentioned that, there's a tendency to criminalize dissent. I can only tell you that last year in the Supreme Court, about 21,000 bail applications were filed in 2024. The Supreme Court disposed of about 21,300 bail applications, which is an indicator that the court, as the apex judicial institution, does value personal liberty.
There have been some criticism against you, in the context of some of your judgments. And the legal luminaries like Dushyant Dave and Indira Jaising, they have pointed out that when you came face to face with the political power, you didn't live up to the promises that were there when you took charge as the Chief Justice of India. For example, the reopening of the Gyanvapi mosque case. It is felt that with that judgment, you really opened up a Pandora's box. And we have seen the tragedy that occurred in Sambal, where 5 innocent people got killed. So, how do you respond to this criticism?
Thank you very much for asking me this question. In fact, I really value this question because I find that so much of the criticism which is leveled not against me personally only, but against the Supreme Court is completely contrary to the facts. It's very easy to sit back on a television camera on the evening news channels and start criticizing the judiciary. The Supreme Court, in the course of its order, specifically directed that worship at the Gyanvapi mosque by the Muslims must be protected and that it must be allowed to go on unabated. We directed that not only worship in terms of the namaz should be permitted to continue, at the same time, the places which are antecedent to the worship, including the wuzu, should not be allowed to be destroyed or obstructed. So far from the Supreme Court having prohibited worship in the course of namaz at the Gyanvapi mosque, the Supreme Court directed that worship should continue. So to the contrary to what is being said by, obviously you mentioned 2 names, a segment of lawyers, is contrary to the reality in the Gyanvapi mosque. Now, the neat question which will be before the Supreme Court and which will be decided by the Supreme Court is whether a place is of historical or archaeological significance. Does this not require a survey to take place?
No,
because this is exactly what the statute says.
Yeah.
And therefore, we permitted, yes, there's a small part of a cellar in the Gyanvapi mosque, where worship by the Hindus has been permitted. But you must be conscious of the fact that the order of the Supreme Court does not stop worship by the Muslims in the Gyanvapi mosque. In fact, to the contrary, a direction was issued to the district magistrate and collector to ensure that our directions have been complied with.
Because the Ayodhya judgment delivered by the bench, including you, it made it crystal clear that the exception has been applied only to the Ayodhya case.
Well, of course, that's right, because that case dealt with Ayodhya, right? And that case really therefore dealt with the evidentiary dispute in Ayodhya. But as I said, I'm not into the merits of our judgment because, I was a party to the judgment, and therefore the critique or defense of the judgment has to vest with the wider society.
One very last question. With regards to the Ayodhya judgment, you made a revelation and you thought it fit to share with the public that how you tackled that moment of crisis and how you arrived at the judgment. So, and there have been many criticisms against that revelation. Many people felt that you shouldn't have consulted the divine spirit instead of holding the constitution in trust, and by giving yourself to the will of the divine spirit, you abdicated the spirit of the constitution. So how do you respond to that?
Again, thank you very much for asking this question, because I think here again, it's important that people should know what the facts are before they jump to conclusions. First and foremost, look at the judgment itself. The judgment spans over 1,000 pages. Every one of those pages is replete with an analysis of the evidence in the case. That different human beings, different judges, have different paths to maintain their sense of equanimity, of balance in the face of conflict, in the intense conflict which arises before the court, including the Supreme Court. For me, faith, meditation, reflection, for which I carve out time every morning, is a very important source for my maintaining the sense of calm which was necessary in my work as a judge. And faith for me is not just faith. What does faith teach us as individuals? Faith as individuals teaches us the universal humanity that resides within all of us. Our Constitution does not require judges to be either agnostic or to be atheist and to be independent. Our judges can be religious in their inclinations and yet do justice for people who belong to all faiths. Now, if people expected that I should be hypocritical enough to deny the value which my own faith has in my evolution as a person, well, I'm not a hypocrite. And I maintain that.
Yeah. Were you pained by the criticisms? Do you regret that decision to share your inner feelings with the public?
Oh no, not at all. I don't regret for a moment that I was not hypocrite when I spoke the truth, even if it meant that a segment of society felt pained by what I felt and what I said. For me, I've never been pained by criticism, so long as the criticism is based on facts. What sometimes pains me is that so much of the criticism is completely based on illusory or assumed facts, which are contrary to what was said or what is contrary to the truth. But well, that's the time in which we live, where people think that they can make target of judges to carry their own status to a higher level. So be it. Our shoulders are broad enough.
Such a pleasure talking to you, Justice Chandrachud.
Thank you so much. It's been a pleasure, and thank you very much for having me here.
Thanks for finally speaking.
Thank you.
Yeah, that's it.